Good day, fellow officers. My name is Nkopane Mokoena. I am an attorney and director of Inc. Attorneys in Johannesburg. My specific area of focus is civil litigation, and I think that is why I am invited to give you this lecture today. I appreciate the invite by my fellow colleague, Ms. Sinokwani, who has since made it a point that I understand that the audience to this lecture are first-year students. What that means to me is I should be very candid with time, and I will try my best to do so. I must say, as a former COFC, it is an absolute pleasure for me to be giving out this lecture. I must also further say that I think for me the best class I have ever had as a first-year student was one which would end within 20 minutes of starting. So I am very cautious of the time, and I won't take too long as long as the content that I have to deliver, the content that I've been asked to convey to you is appropriately delivered. Then all our work will be easy, and I will be the happiest person around. So Ms. Sinokwani had requested me to particularly address, to give practical guidance insofar as practice is concerned, from the time you serve your articleship to the time you become admitted, to the time you practice, which could be quite a long journey, which also could be quite a lonely journey. But it's not for me to give you that. I just want to give you a practical view of how things are in practice. So I will be focusing on the court system. I will be focusing on the role players in our profession, in particular the role players in litigation. I will be focusing on the distinction between the attorneys and the advocates, and the tasks that you will be faced with as a practitioner. But first, before I begin, I want to say you ought to get yourself this book. This is an act. It's the Legal Practice Act. This is currently the act that's governing the profession. So it's in essence, if you are a legal practitioner, this is your Bible. This has to be your Bible. So please get yourself the Legal Practice Act. The copies are available on Google. It will give you an overview of what the profession looks like. So, and it will also give you a clear picture of where the profession wants to go, where the Legal Practice Council envisages that the attorneys as well as the advocates profession would be in years to come. Also, in terms of the ethical conduct of legal practitioners, this book, this act is what will guide you. So please get yourself that, have a look at it. It will assist you in terms of understanding how the profession works or ought to work. So I want us to begin with the role players, especially at court. So, or perhaps, what is litigation? Litigation is simply a process of parties suing each other or seeking various remedies from court. So sometimes you have, applications where there's only one party. That is still litigation, because it involves the process of court wherein one party seeks a remedy from a court of law. So the party is involved in a litigious process, and it's basically what constitutes civil procedure. It's basically what constitutes civil procedure, and that's what guides the courts. The role players that we have in our process are as follows, some of which you may have heard about. So I'm not going to spend too much time describing these people, but we have the judges whom you already know that judges are simply the presiding officers at court who are appointed by the Judicial Services Commission, shortly described as the JSC. These are the people who are tasked with the duty to preside over matters, to ensure that attorneys or advocates who appear at court are heard and the parties obtain a justified relief. So you have the judges. Then secondly, we have the registrars. Now, registrars are the court staff, the people who deal with the administrative work of court. For example, when you go to court and you file documents, you're going to file with the registrar, not directly with the judge, because the judge must get the documents at the stage when the documents or the matter is ripe for hearing. So registrars are one of the most important people you'll have to come across in practice. I'm here to give you a practical guideline. The most important person that you have to respect, regardless of what qualification you hold and what qualification they hold, is the registrar or clerk at court, because those are the people with whom you will interact the most. You will hardly see the judge. You will only see the judge when you go and introduce yourself at the date of trial or at the date of the motion. So it's extremely crucial that for every step that you have to take in litigation, you must understand the role of a registrar, and you must maintain extremely good relationships with registrars across courts which you will be working at. That's extremely crucial, and I hope you remember it for the rest of your life. We have the sheriff. So the rules requires, especially in the High Court, that a sheriff must be appointed in order to serve documents like summons. Who is a sheriff? A sheriff is simply an officer of court who is appointed as a messenger to deliver documents that are court documents. So a sheriff is appointed by the attorney in order to serve the other party, and then the sheriff will come back with what we call a return of service. A return of service is a document which proves that the other party to the litigation received the documents which were served on them. So often it's summons or an application itself. So the sheriff is an extremely important player in the entire profession, in how litigation works. And then you have the family advocate. The family advocate is someone who's in general involved in matrimonial property matters, yes. So a family advocate's role is to take care and ensure that the best interests of the children are taken care of, that are seen to, that they are fulfilled. The family advocate is often appointed by a court order to investigate the best interests of the children. So the family advocate works with the children and is a statutory office that is established in terms of the Children's Act, and in order to ensure the best interests of the children. We have the interpreter. So in court, often you find that the litigants or the witnesses do not speak, the court either of the court languages. So you have to have an interpreter who's going to interpret the proceedings to the litigant, and the litigant in return would then respond in their language, and then that would be translated into the court language by the interpreter. Crucial role. You also have what we call the court orderly. This you often see in magistrate court, where there would be a court orderly from the SAPS, South African Police Services, who is there to ensure order in the court. So I think you may have seen, if you've watched TV, that in criminal proceedings often what you would see is there would be someone who would keep the crowd to silence in order to respect the court proceeding. That person is called the court orderly. You also have the judge's clerk. Quite important. The judge's clerk is different from the registrar of court. Don't get the two mixed. The judge's clerk works directly with the judge. The judge's clerk is like the PA to the judge, the personal assistants of the judge. They get the files in order for the judge. They assist the judge with the administrative work of the judge's matters. They also, in the event an attorney or an advocate wants to see the judge, they have to go through the judge's clerk. The judge's clerk is the one who knows the diary of the judge, who will then make an arrangement with the judge and check the availability of the judge before you could go and introduce yourself as a legal practitioner to the judge. So this is an extremely crucial person. If you keep this person happy, you certainly are keeping the judge happy. That's a tip. But the difference now is the judge's clerk works directly with the judge, and the registrar is the registrar of court in general. So when you file, you go to the registrar. When you specifically have a matter that seeks the judge's attention, then you go to the judge's clerk. So each judge has a clerk. So that's how it is, you know. So just keep that in mind. That's the picture you will have, you know, when you get into practice. It becomes more easy for you to process and simply absorb. We also have the stenographer. The stenographer is someone in court who takes notes and ensures that there's a record of proceedings. In order, this assists in an event where an appeal lies at a later stage, then the stenographer is able to then produce the record of proceedings in order to have the judge on appeal be able to read through the record of the proceedings which had already taken place. Then you have attorneys and advocates. I'll deal with the distinction of the two. Then you have the Master of the High Court. The Master of the High Court, as you would know, is appointed by the minister in terms of Section 2 of the Administration of the Estates Act. His duty is simply to administer the deceased estates. And as you would know, this includes things like, submission of reports to the court, especially where insolvency is involved. But this also includes people submitting requests to be appointed as executors, or getting letters of authority to act for or against the estate of the deceased. So the master is simply a body that is established in terms of the Deceased Estates Act. In fact, Administration of Estates Act, apologies, which basically focuses on the entire administration of the estate. Then you have the prosecution, the prosecutors, from the National Prosecution Authority to the regional prosecutors, local prosecutors, and stuff like that. So these are people who are states lawyers who specifically prosecute matters on behalf of the state. So you would imagine they do a lot of criminal work. And then you have the Registrar of Deeds. This is an official that is appointed in terms of the Deeds Registry Act, and often submits reports to court in disputes concerning immovable property. So they deal mainly with houses and stuff like that. Now, that's in a nutshell the role players that you have in the legal profession. Without any further ado, let's discuss the elephant in the room, and that is the advocates and the attorneys. So, as I said earlier, this book seeks to merge the two professions of attorneys and the advocates. But it will obviously be a very gradual process. They are doing so through a non-distinction, which was historically very prevalent in our profession. For example, the Legal Practice Acts now permit the advocates to obtain instructions directly from a client, which was historically impossible. So Yeah, but let's start where we must, which is to give a brief historical background to that. Like in England, South Africa has a split bar system consisting of attorneys and advocates. The advocate's profession is a referral profession, which means that the advocates cannot accept briefs directly from clients. This is a historical position. The attorney is approached by the client, and it is the attorney who takes instructions. After the attorney has taken instructions, the attorney would then brief the advocate. An advocate is also called counsel, who then they generally provide strategic advice and settle the pleadings and represent the client in court or in arbitration proceedings. There are terms that you may not be familiar with. I'll just try and break it down. So in essence, the attorney accepts the brief from the client and drafts the necessary documents, drafts a brief. A brief is simply instructions from an attorney to an advocate. So there's a specific format on which a brief should be drafted. Then the attorney takes the brief to the advocate. The two will then consult on the matter. The two will then decide on a strategy on how they will be working on that particular matter. And then the attorney in ordinary circumstances would draft the pleadings. Then the advocate would settle the pleadings. Settling means the advocate would oversee the pleadings and finalize the pleadings. So that is simply the distinction in terms of, or rather the symbiosis, the relationship, the synergy between attorneys and advocates. Advocates are either senior or junior, or silks. So as you would know, a junior advocate is someone who just got into the profession of advocacy, who is less than 10 years into the profession of advocacy. And a senior advocate is someone with 10 years or more experience, and a silk is someone with who has obtained the status of a silk, which is a status that is granted by the president, which takes into cognizance the experience of an advocate, the length of service of an advocate, the matters of public interest which the advocate has appeared on, and considerable other factors which would then determine if counsel is to be conferred a status of silk. A status of silk is a concept that comes from the English common law, wherein in England the Queen would confer what they call the Queen's Counsel, the QC, the Queen's Counsel, and the Queen would be the only one with those powers to then confer that status upon counsel. In South Africa, we adopted that concept from the English common law, and it's referred to as a senior counsel, SC, and not QC, but it comes from the same concept. Now, once attorneys who have obtained a right of appearance may appear in the High Court, they may choose to do so. The current position in terms of the Legal Practice Act is that an attorney must first be admitted for 3 years, and then an attorney may apply to the High Court to obtain a status or right of appearance, and the High Court will grant that, you know, if it's convinced that the attorney should be at the level where they should be allowed to appear. It's quite a conundrum, really. What you would ask yourself is, what is the difference between an advocate who comes directly from pupillage and is now just admitted as an advocate and now has a right of appearance in the High Court, against an attorney who has done their articles, law school and all of that, and is now an admitted attorney of the High Court? You would ask yourself, what is the difference between the two? Why would one be preferred to be conferred a right of appearance by the High Court and the other not? I will leave it to you. You will ask yourself. It's, to me, it doesn't make any, formal sense, but it's not for me to say. My role is to just give you the practicalities of how the profession operates. That's currently the position. That's currently the position. I think the other important thing is that when counsel is briefed, the role of the attorney is to instruct the advocate on behalf of the client. And advocates may consult with clients unless instructing attorney may not consult with clients unless the instructing attorney is present. But that's one of the many things. What is happening now is this act again has come and it has changed that position. In terms of this act, now an advocate may obtain a right to consult with their clients directly. But what that means is they must first have a trust account, and they must first do accounting, which is what attorneys do. And then they must be able to then obtain instructions directly from clients. So what the profession has sort of done after the coming into effect of this act is they have advocates who said, we are happy with the previous position. We continue to take instructions from our attorneys. So we're not going to do any of those, requirements for us to obtain a trust account. We don't want instructions directly from clients. We are happy with the status quo. And then there are those advocates who said, well, we're happy with the proposal. The proposed position works for us. And what they have since done is they have went to do bookkeeping. And they have applied to the Legal Practice Council, which was formerly known as the Law Society. And they now obtain instructions directly from clients. So you have a parallel system of how the profession of advocates operate. You have those advocates with the power to obtain instructions directly from clients, and you have those advocates who don't have the power to obtain instructions directly from the client. Now, that being said, that constitutes the entire profession of advocates. Now, the profession of attorneys separately is such that attorneys are trained through the process of candidacy. So you become firstly a candidate attorney, having obtained your LLB degree. You will serve 2 years of articles in a law firm, or you could serve 1 year and 6 months if you, provided that you do practical legal training, which is now referred to as vocational legal training in terms of the new act. So during the process of your articles, here are the important things that no one at school will ever teach you. One, you must learn to respect your clients. You must learn to respect the opinion of your boss, who will be your principal. You must learn to respect the colleagues around you. This is where you come in and you have the little knowledge that the LLB has given you. But what you will be dealing with there will be totally different from what they are teaching you back at school or what you were taught back at school. And I'm saying this because it's a very practical environment. It can be extremely gruesome. If you come in with attitude, it can be extremely gruesome if you're going to approach it with attitude of I know it all. So what I want you to understand is, when you get to a law firm, you must know that you do not know anything. You must know that you do not know anything and be willing to learn. Now, as a candidate attorney, part of your duties would be to write letters. It would be to file documents at court. It would also be to appoint a sheriff, and you must know how these things are done. So just to bring you into it, at the beginning of the matter, you sit for a consultation with your client. You absorb the facts, you distinguish the relevant from the irrelevant, then you bring together what your client's case is. What you then do is you research the law that is applicable, and you assess if your client in fact has a case or in fact not. And you advise your client accordingly. So what you would do if you have taken instructions, once you are satisfied that there are merits to your client's case which are worth pursuing, then you will draft a letter of engagement. What a letter of engagement is, it's simply a letter that confirms that the client has instructed you and that you will assist the client, and you outline just briefly the time frames and all of that. Ethically, you must also give a client what we refer to as a cost estimate. What a cost estimate is an estimation of the fees and the disbursements that the client must expect to incur. That said, you must further send the client what we refer to as a memorandum of advice. A memorandum of advice is an outline of the strategy that you will employ to obtain a remedy that your client would be entitled to. It will also be to inform the client of what their case in law is. Now, having drafted all these documents, which are quite crucial, extremely necessary, you can't get beyond this unless, a matter is such that of extreme urgency. And obviously you can't do certain things as you would otherwise do. If you fail to do that, and you do work, but you did not send a cost estimate to your client, there's no fee agreement, there's no fee mandate, and your client refuses to pay your fees at the end of the matter, then you don't have a case against your client. You simply don't have a case. The Legal Practice Council is going to ask you, did you receive financial instructions? And if not, then on what basis were you acting? Because there would not have been consensus. There would not have been a meeting of the minds insofar as the fees are concerned. So be on the safe side. And it does not matter what happens. I always say that make sure that the client knows what your fees are. Otherwise, you run on the perilous. And you will regret, because the council is quite strict when it comes to the members of the public. By all means, the intention is to protect both practitioners and the members of the public against each other and against external parties. So be very cautious in your relationship with your clients and keep it as professional as it gets. As I've said, a letter of demand is the first step to instituting the legal process. While a letter of demand is required, it does not need to be sent in all circumstances. So it is, however, usual practice that a letter of demand would be sent before instituting legal proceedings. A letter of demand is as its title suggests, it's simply a letter that demands a particular fulfillment from the other party, which the client is, by all reasons and belief, entitled to. So it is not a requirement that a letter of demand would be sent in all matters. It is however, advisable, because before getting to court, you must employ all means necessary to try and amicably resolve the matter. So it's part of that. But in certain instances, like matters concerning credit, credit disputes, consumer disputes, section 129, section 129 requires that a letter of demand must be sent, so it's it becomes peremptory. It becomes a non-option. It becomes compelling that a letter of demand would have to be sent. So just be cautious of that. And then now, once you've drafted a letter of demand, the next step would be, depending on the type of matter you are dealing with, you have to distinguish between action proceedings and application proceedings. How do you do that? As you would know, you would be having the facts of your client. You would understand from the consultation what is, the facts, the circumstances, the background, and what sort of remedy is being asked of you by your client. Having understood that, what you are able to say, is there a material dispute of fact? What do I mean by that? Having looked at the facts, do you foresee that you will need witnesses to come and testify to court? Then you tick yes. Do you foresee that there will be a dispute insofar as the material facts are concerned? Material facts are facts that constitutes the crux of the matter. Yes. Then once you have these two ticks, what you're sitting with here is an action procedure. So you have to institute action proceedings. Action proceedings are instituted by way of summons. So you may ask yourself, but why? Why action proceedings and not application proceedings? Action proceedings are only instituted where there is a material dispute of fact, or where there may be a material dispute of fact. What that means is that, as I've sort of explained, the matter cannot be resolved on paper alone. The judge will need to hear evidence. So that is in essence why you will have to then institute action proceedings. Now, in the event when you assess the facts before you, you realize that in fact what I'm sitting with here is there's no material dispute of fact. And I'll make an example. Your client A entered into an agreement with B, wherein A had agreed that he will make payment of 5,000 rands in order for B to deliver specific services. Now, A pays B 5,000 rand. B fails to deliver. For no reason or no reasonable ground. Now, the facts are that your client entered into an agreement with B. In terms of this agreement, your client would pay B 5,000 rands, undisputed. All of these are undisputed facts. In return, B would then deliver specific services to your client A. There's no material dispute there. There's no need for an external witness. So the court can look at this matter and say, where's the contract? Here's the contract. Okay, I see the parties agreed. Then the court can make a determination just on those bases. So it can be considered on paper. And that's when you know that you are dealing with application proceedings. I want us then to, having distinguished between, on one hand, action proceedings, and on the other, application proceedings, let's now dwell into the action proceedings. Action proceedings are instituted by way of summons. But what are the summons? Summons, let me just perhaps discuss it in this way. I think it may be very practical if I do. The issue and service of summons commences the action. It commences the trial action. The purpose of summons is to bring the plaintiff's claim to the attention of the defendant by informing the defendant of the nature of the plaintiff's cause of action and the claim made. So the summons generally informs the defendant that it has 10 days within which to deliver a notice of intention to defend. The action, within which they have 10 days to deliver a notice of intention to defend, and that failure to give notice within that prescribed time will allow the plaintiff to apply for a default judgment. Before I go further, if you intend on being an attorney or an advocate who's going to deal with litigation, this book right here has to be your Bible. So this is a book which entails the Magistrates Court Act, the uniform rules, the rules regulating the conduct of proceedings in the Magistrates Court, and the Superior Courts Act. Now, so anything you need to know about how courts operate, how civil litigation operate, this is your Bible. So it's an interesting book to have. Not so interesting if you're not interested in litigation, you know, but it's an interesting book to have, because everything is regulated by the rules. There are time frames within which, as I have said now, one may deliver their summons, one may deliver their notice to defend, one may apply for a default judgment, one may apply for a summary judgment, are entailed in this book. And if you don't have this book and you're practicing and you're dealing with civil litigation, God forbid, what are you doing? Another book that I will recommend is Amla's Pleadings, or Precedent of Pleadings. Amla's Precedent of Pleadings is a book that will guide you in terms of various civil claims, from contractual, delictual, enrichment, unjustified enrichment. You will get all that content insofar as precedents are concerned from Amlas. It's a very good book, assists a lot with drafting. Now, having seen all this content, so summons are basically that document that begins a trial, wherein you outline the claim of the plaintiff, simple terms. But we have different types of summons. We have simple summons. We have provisional sentence summons, and we have combined summons. What's the difference? So, simple summons, the distinction depends on the nature and complexity of the plaintiff's claim. That determines which type of summons you are to use. So simple summons are used in a cause of action, or when the cause of action is based on a debt or a liquidated claim. Let's explain that. If you have an overdraft facility from any of the banks, and the bank is coming after you, this overdraft facility constitutes a liquidated debt or document. So the bank can institute process by a simple summons. Or alternatively, another example would be if A signs a check to you, and in terms of which you are supposed to then pay A something in return or do some particular work, but the check is signed to you, that check is a liquidated document. So that's when you will then choose to use simple summons. A combined summons is used when the plaintiff's claim is not found on a debt or on a liquidated demand. In addition, in simple summons, there will be no detailed particulars of the claim attached, as is the case with in a combined summons. So just practically speaking, this client comes to you and says to you, listen, I have these issues with whomever, the other party, and the matter is so complex that there's a lot of events that have happened. You may need to call in witnesses to give account in general of what transpired and to prove your client's case. Immediately here, what you're looking at is there's no liquid document, there's no liquidated claim, there is no actual debt that you can produce to court and say this is proof of a loan or something. So what you're dealing with here is a combined summons where you're going to outline the nature of this claim and bring it to the attention of court what your client seeks there out of. Then you will have to use combined summons. But if you have an agreement that is a matter of dispute, or you have evidence of a debt that is was agreed and there's a document, liquid document, that then what you do is you simply do not provisional but simple summons. Simple summons just says A owes B this much. This is when the money was transferred into A's account, and then A has failed to pay the loan back, and we attach here with the document, which would be the loan contract or whatever, or overdraft facility contract. And as a result, we want the court to make an order against A that would be for this much, and then you submit that at court. That's simple summons. But combined summons goes with particulars of claim. Particulars of claim, as we have correctly said, details out the nature of the claim your client seeks or has, and what relief your client seeks from the court. Now, having drafted the summons, what now becomes there's a type of summons I need to explain as well to you. So I've explained combined, I've explained combined, I've explained simple. I'm going to explain provisional sentence summons. So a provisional sentence summons is a rare process in civil litigation. It is an extraordinary procedure in terms of which the plaintiff is in possession of a document showing an indebtedness for a liquidated sum of money. For example, a check. You may obtain provisional judgment for the amount that is payable on the face of the document prior to the trial date. But the rationale behind is that the court will grant a provisional judgment in favor of the plaintiff on the basis that in issuing the document in question, the defendant has acknowledged its indebtedness to the plaintiff for the amount stated in the document. So the court must provisionally be satisfied that the plaintiff will succeed in the principal case. So this is a speedy process. It's a speedy process to recover money that has been owed, but there must be a liquidated document, like a check that proves a sum of money that was granted, borrowed, or loaned, to the other party. So the purpose of provisional sentence summons, as I've said, is to bring a speedy and effective resolution to the matter. But you will obviously face those where the defendant would now be opposing and disputes the claim. Then the onus rests with the plaintiff to prove that the claim that the plaintiff is making is true. So that's basically three types of summons. It's the combined summons, simple summons, provisional sentence summons. Now, what you would then do after you have filed your summons, and at court, what you do is you go to court with your summons. You request the registrar to issue the documents and to allocate a case number to your matter. Once you have this, a copy of your summons would remain in the court file, and but courts differ in terms of how they work with this. Some just say, take all the documents out, they just open a file for you, then you'll come back after the sheriff has done their job. But anyway, let's use this simple example. You leave a copy of, an additional copy of your summons in the file with the case number. Then you take the original, you take the copies, and then you appoint a sheriff. Then a sheriff will go and serve the summons to the other party, and the sheriff will then come back with what we call a return of service attached to the original summons, and they will give you those documents. Then you take those documents back to court, you file the original copy of summons with the return of service in the court file. Then within 10 days of receipt of the summons, the defendant must enter what we call a notice of intention to defend, which is self-explanatory really. It is a notice that indicates that I intend defending these proceedings. Then within 20 days, that's within 20 days of the delivery of the summons, the defendant must enter their plea. A plea is a document which outlines the nature of the defense to the claims which have been made by the plaintiff of the defendant. So it is simply a statement of defense. This is now when the defendant responds to the claims that have been brought against him or her by the plaintiff. What then happens in the event that the defendant fails to enter a notice of intention to defend within the 10 days? The plaintiff may apply for a default judgment. Once the 10 days have expired, the plaintiff may apply to court for the court to grant a default judgment. A default judgment is a judgment that the court may grant on the basis of the particulars of claim and summons alone, which means that you will be saying to court, the matter is not defended, so there is no defense, therefore grant me the remedy that my client seeks. And the court may grant that if it has satisfied itself that all is in order. Okay, what happens when the defendant enters an intention to defend but does not enter a plea, a statement of defense? Now, failure to enter a plea within the prescribed periods entitles the plaintiff to deliver what we call a notice of bar. A notice of bar is a document that the plaintiff will deliver to the defendant after the 20-day period has expired, calling on the defendant to deliver their plea within 5 days of receipt of that notice of bar. Should now the defendant fail to do so, then the defendant is barred from delivering his plea, and the plaintiff may then apply for what we call now a default judgment, still, as the defendant would have failed to defend the matter. So, but in practice, however, before the defendant, before barring the defendant from the pleading, the plaintiff attorneys will ordinarily, as a matter of collegial courtesy, send a letter to the opposing attorney and say, listen, the time is up on this matter. the plea, or rather the summons were delivered to you on this day, the notice of bar was delivered to you on this day, you have not pleaded, and you're out of time. So please do plead. Otherwise, we will be left with no option but to approach the court for a default judgment. Now, that is just, ultimate courtesy, but you don't want to find yourself in that position where your client is asking themselves, am I really having a proper attorney here? Why would you be out of time, Unless if there are compelling circumstances which you can then, plead to court. But the plea must be, the plea, which is now, we said, it's a statement of defense. It must set out the defense upon which the plaintiff relies. The defendant relies, and must contain paragraph by paragraph reply to each allegation, and that was made in the defendant, in the plaintiff's document. Now, there's an option for the defendant to also claim through in the same matter, what we would call now a counterclaim. So the defendant will plead a defense, and if the defendant wants to claim in the same matter with the same facts, then the defendant would then do what we call a plea and a counterclaim. Now, a counterclaim is a statement of claim by the defendant. So how the documents would be, it would be the plea, where the defendant would say their defense, and then subsequently it would say counterclaim. Now, this is where the defendant now makes a claim and becomes the claimant. I don't want to confuse you. So it's called a claim in reconvention. So in this matter, you will have the plaintiff, which is your client, as someone who's a claimant, but at the same time, you'll have the plaintiff, who's your client, as the defendant to the counterclaim. And then at the same time, you'll have the defendant to the plaintiff's claim as the defendant, and the defendant as the claimant to the counterclaim, a claim in convention. So I don't want to confuse you. I think it becomes more practical when you actually do it. But in a nutshell, a claim in reconvention is the defendant's separate cause of action against the plaintiff, which arises from the same facts and from the same matter. If the defendant wishes to bring a counterclaim, he is obliged to do so when filing his plea. He can only do so when he files his plea. So the plaintiff does not need to deliver a notice of intention to defend to the counterclaim, but the plaintiff must then deliver their plea to the counterclaim. So it's called plea in reconvention, in which the plaintiff must set out their defense to the counterclaim, and the plea to the counterclaim must be delivered at the same time as a replication, if one is to be delivered. Now, what is a replication? A replication is the plaintiff's response to the defendant's plea, and is necessary only when the plaintiff wishes to place new facts before the court or to clarify issues raised in the counterclaim. Right. Now, we've discussed what a plea is, what a counterclaim is, what are summons, what is the notice of intention to defend, and the time frames within which this may be delivered. We have also, discussed what the plea is, and, the importance of a plea. It's an extremely important document, because without a plea, then there's no defense. So I think another important thing that I wanted to put across is, if the defendant enters a notice of intention to defend and enters a plea, but you still believe as the plaintiff that despite this being delivered, there's no defense. Having read the plea, There's no defense, and the intention is only to delay. So it's a dilatory tactic to just cause, frustration to the proceedings. What you are to do in that circumstances, you may still apply for summary judgment. So you go to court and make an application. Your summary judgment application will basically be informing court that, court, I have read the plea of the defendant, and I believe that there is no defense. There is no material defense. There's no practical defense. In fact, the plea is entered with an intention to delay the matter. Then what the court will do is the court will ask the defendant to explain or themselves to the allegations you're making, or the court may just simply read the plea of the defendant, and it will make a determination. If you are correct to say that there's no actual defense, and therefore, if the court is satisfied that there's no actual defense, it will grant what we call a summary judgment, which will be a judgment in favor of the plaintiff on the basis that there's no actual defense to the claim by the defendant, So that's quite important. But more importantly, and this is something which is we are encouraged to do all the time in practice by the courts, by fellow practitioners, settlement negotiations. If a matter is capable of settlement, settle it. Why? It's cost effective, it's efficient, it's speedy. And when a client comes to you, they don't want to see how good you are with speaking English. They don't want to see how good you are with, arguing in court. That's not why clients employ lawyers. They employ you to give them a solution, and in the most effective way. So always make it a culture that you open settlement negotiations on all your matters for as long as it is possible to settle the matter. Remember that. Now, the trial itself, after the summons have been served and filed, the intention to defend has been entered, a plea has been filed, then the pleadings will close. Now, once pleadings have closed, we are now at a pre-trial stage. We're about to go to court. The rules require that, I think it's rule 33, requires that parties must discover. What discovery means is there must be documents which, if you intend to use as evidence, the other party must be aware of. So they must see the documents before you go to court, so they can prepare defense against those. So it could be documents, it could be items, it could be any form of evidence. So they will do a notice of discovery, and they will exchange those notices, and both parties will produce what they intend to use as the evidence at trial. And then once that is settled, we have what we call a pre-trial conference. A pre-trial conference is a conference between the parties where you try to narrow down the issues. So it's not in terms of any act. It's not also in terms of the rules. No, pre-trial is in terms of the rules. But mostly it's in terms of the practice directives of a specific court. So the court would require, in terms of its directives, that practitioners must sit and discuss the content of the dispute. In other words, try and narrow down the issues so that by the time you get to court, we know facts which are disputed and facts which are not disputed. We know facta probanda and facta probandia. We know what the court has to deal with, So the pre-trial conference will assist with that. Then it's always best to sit in a pre-trial conference at an office of your opponent and get it done. By the time you go to court, the directive will say, but we need to have a judicial pre-trial on this matter. Then you say, no. the judicial pretrial may be held, but here are the minutes of the actual pretrial that we had in our office. That means the judge now doesn't have much to do. The judge says, okay, the matter is right for trial. Then the judge will set the matter down for trial. Now, the trial itself, all right. So now, the trial is the hearing, the actual hearing by the court of evidence to the dispute. So a single judge will be allocated to the matter, but obviously this depends on the nature of the matter. A single judge will be allocated. If it's an urgent matter, obviously it's not a matter of a single judge. There'll be two judges sitting on bench, so just note that. So generally, the party making the claim bears the onus to prove their claim. As such, the plaintiff usually starts with its evidence, and any claim must be proved on balance of probabilities. Civil litigation, balance of probabilities. Counsel for the plaintiff will usually give an opening address to the judge. This is intended to provide the judge with an overview of the case. This is extremely important because I see practitioners getting it wrong most of the time, wherein a practitioner introduces the case to the judge by saying a lot of convoluted issues which should form part of the content of the arguments and not the introduction. So in essence here, what you're doing is you're introducing the case. When you introduce the case, you hit the judge with one statement that defines what the judge is focusing on. One statement that should define for the judge what the judge is to deal with, what your client's case is. I remember one famous case, the Oscar Pistorius case. If I had to open that statement, or as for the state, if I had to open the statement for the state in court, I would have told the judge that this is an extraordinary case involving Shakespearean proportions. That's it. What the judge then understands from here is, here you're dealing with an adverse event which occurred out of romance. You're dealing with an adverse occurrence which took place out of romance. So practitioners get it wrong all the time, but that's important. Opening statement. The plaintiff's counsel will open the statement and introduce the case to court, and then and provide the judge subsequently with an overview of what the case is about. But this is not going into detail. You're still saying the judge, these are the issues that you will have to decide on the matter. This is what the plaintiff will argue, and this is what I'm preparing you for, to be ready to hear, to understand the context. Now you deal with now what we call oral evidence. That's when now the plaintiff will call its witnesses, and then these witnesses will come to the stand, and those witnesses may be cross-examined by the defendant, and then thereafter you may re-examine. I think there will be a module that deals in detail with the entire process for you to sort of understand properly. But further, you will then deal with after the whole witness has been called, the defendant will then at a later stage call its witnesses, and a same process applies. Examination in chief, cross-examination, and re-examination. Then you have an option of calling experts as witnesses. Expert witnesses can only give the evidence as experts, but that expert evidence is not compelling to court. The court may disregard, the court may consider. It's only to guide the court to an appropriate decision, but the entire discretion rests with the court. In the event you have witnesses that you want for to participate in the matter, but are not there or are not willing to come, you may ask the court to issue out what we call a subpoena to get those witnesses to come through to... Now, lastly, now I'm going to deal with the application procedure. Now, the application procedure is simply the process. Now, as you would recall in the beginning, I introduced the distinction between the action procedure and the application procedure. Now, application procedure is now where we're dealing with the having looked into the facts, we realize that there's actually no material dispute of fact here. So we want to take the matter to court, and there's no material dispute of fact. We don't need to call witnesses to come and testify orally at court. We can get confirmatory affidavits that would suffice as evidence to the process. Then you know that you're going to use application process. Why is application process ideal? It's ideal because it's speedily, it's efficient, it's also cost effective. A trial can take 2 years on exchange of documents, exchange of witnesses, examination in chief, cross-examination, and stuff like that. But with application proceedings, you don't take long. It only takes filing of papers by both parties, consideration by the judge. The matter may be considered on paper, and the judge may give a ruling in chambers. Alternatively, the judge may want to hear the practitioners, so they may come to court and make their arguments, and then the judge may give a ruling thereafter. So it's quick and it's ideal. So how does an application process begin? It begins by a notice of motion. Now, you would note as well that application proceedings are either called motion proceedings or application proceedings. They begin by a notice of motion followed by an affidavit. This affidavit will be a founding affidavit. Now, what the founding affidavit would entail is a claim. It would be the facts to the matter. So it will be the background and facts to the matter, and course of action, the remedy. What does the client want? That's what that affidavit will entail. Further, the notice of motion would then entail the prayers. What does your client want? So you'll be notifying the court that you want to bring this matter before it on this date and time, and what you want is 1, 2, 3. That's all this is about. That's it. All that you would have done is the entire affidavit would have annexures of any other evidence you want to use. If you have a contract that you want to attach it. If you have confirmatory affidavit from a possible witness, attach that. Now, after you have drafted these documents for your client, you go to court, you request the registrar to issue the documents and allocate a case number. After the case number is allocated, you appoint a sheriff to go serve the other party. Now the sheriff goes and serves the other party. The other party, within 5 days of receipt, you must note the differences here. Within 5 days of the receipt, must file an intention to oppose. Here's the first difference that I want you to pick up. We said in action proceedings, after you have served, or the sheriff has served the summons on the defendant has 10 days, within which they must file a notice of intention to defend. Here we are saying in an application process, after the application has been served on the opposing party, who would be called the respondent, then the respondent must file their notice of intention to oppose, not to defend, to oppose. within 5 days, not 10 days. Now, after the intention to oppose has been filed, within 10 days, within 15 days of receipt of the application by the respondent must file an answering affidavit. This is now the affidavit outlining the defense of the respondent, or the respondent's opposition to the claim. Now, this will be served within 15 days of receipt of the founding affidavit and the notice of motion by the applicant. Now, the applicant may then, having looked into the answering affidavit, if it's necessary, and do mind this, if only it's necessary, the applicant may file a replying affidavit. The applicant may file a replying affidavit replying to the allegations that were raised in the answering affidavit, which were not covered in the founding affidavit of the applicant. But this is only if there are new facts which arose out of the answering affidavit that you find the need to respond to. And your replying affidavit may not raise new facts. It must only stick to the facts which are already established in your founding affidavit and reply accordingly to the facts which are raised in the answering affidavit. But you can't raise a new claim. Then after this, parties will file and pleadings will be closed. Pleadings will be closed. Now, when pleadings are closed, what parties then will do is, again, try and settle the matter. Speak to the other party and say, listen, do you have an offer for me on the table? If they do, it's fine. If they don't, it's also fine. Negotiate that. If you are unable to settle the matter, then the applicant or the respondent may approach the court and apply for a date of the hearing. Once the court grants a date of hearing, the matter will be set down and parties will appear and parties will argue the motion and the court will make a determination. Now, once all this process is done, what you would have done is you would have completed the process, and the court will give an order or a judgment. So this is motion proceedings or application proceedings. So there are different types of applications. What we have just dealt with here is a normal application that may be lodged to court. But we have what we call an ex parte application. That's where there's only one party to the proceedings. That's when an advocate wants to get admitted as an advocate or an attorney wants to get admitted as an attorney. There's no opposition to that. So the advocate will file an ex parte application and follow the same process, except only there's no party to serve, and then get the date, and the court will then grant or dismiss the application. So that concludes the entire process of action proceedings and application proceedings. I do really hope that this was extremely helpful. I hope that you do remember these things, because this module, legal practice, is extremely crucial because it's practical. And the first thing that you will have to do when you get into practice, whether you go into attorney's practice or advocate's practice, is things that they taught you in legal practice. Trust me. Make sure you remember them. Make sure that you understand them, because No one is going to teach you in practice. Your principal is not there to teach you. They are there to guide you. So when you get into the firm, it is expected that you know. So rest assured, if you don't know these things that we have discussed today, then you are in trouble. If you don't make it a point that you know these things that we have discussed today, make it a point that you read through, and maybe you recap, maybe you do your research. I'm happy to send a guideline for the whole civil process to Ms. Sinokwani. I think upon request she will send it to you. We'll send it to her, and I hope this was fruitful. I had a good time telling you about legal practice and its complexities. I hope you enjoy. I hope you make fine legal practitioners in future, and I hope this is an enlightening moment for either all of you or some of you. Thank you.